Okay,
There
is
we go.
everyone here and ready to go on the Pro Blue Racer Green versus Pro Carsa case?
Yes, Ron.
Yes,
Mark
Your Honor.
Ste Mark Stedman for Steel Professionals. Can you
Good
hear me
afternoon.
okay?
Yeah,
Yes,
I'm so sorry. My court reporter just signed on, so let's start over again if you don't mind.
Yes, Your Honor. Mark Stedman representing Steel Professionals. It's our motion.
good
Okay.
afternoon, Your Honor. Jason Irvin on behalf of Procarsa Tube and Pipe and Industrial.
And Your
Okay.
Honor, Whitney Beckworth and Mary Lynn Smitherman on behalf of the plaintiff Blue Racer.
Okay. Anyone else here?
No, Your Honor.
Let's proceed.
Thank you, Your Honor. I'm going to go ahead and share my screen just so that you can see my outline.
Sure. Go
Okay.
ahead.
Let's see. Okay. Can everyone see this PowerPoint page?
Yes.
Okay. Your Honor. So Steel Professionals is filing a motion seeking leave to file two claims, essentially. The main one is a claim for statutory indemnity under Section 8202, and the elements of that are that any
Oh, I'm sorry,
seller.
Tony, this is on the record. I apologize. You need us to start over again?
Uh, yes.
Sorry. We're
Yes,
to start. I apologize. We're to start over again. Everyone make their announcement in the case name, please.
Mark Stedman representing Steel Professionals. It's our motion.
Jason Irvin on behalf of Procarsa Tube and Pipe and Industrial Procarsa.
And Whitney Beckworth and Mary Lynn Smitherman for the plaintiff Blue Racer Midstream.
Okay, so start over again, please. Sorry.
If it pleases the court. Steel Professionals is seeking leave to file a claim for statutory indemnity and declaratory judgment that Steel Professionals is an innocent seller. We could phrase it as an affirmative defense, but as the motion is written now, we're seeking a declaratory judgment. The statutory indemnity claim would be brought under Section 82.002. The elements are that any seller may seek indemnity from a manufacturer as long as that seller is not independently liable due to negligence or intentional misconduct or some other wrongful act or omission. And a manufacturer is generally deemed to be a seller also, although not all sellers are manufacturers. So in a products liability action, this is when this is applicable for products liability actions, and that is as determined by the plaintiff's pleadings alone. We would seek to bring this claim against Industrial Procarsa SADCV as a manufacturer, as the operator of the mill that welded the pipe together, and then at Procarsa SADCV as a manufacturer, as holder of the API license under which the pipe was manufactured. Now there is an appeal pending for jurisdiction as to Procarsa SADCV, which I'll address in a moment. We'd also seek to bring the claim, at least as it stands now, unless the issue of jurisdiction is resolved against Procarsa Tube and Pipe Company, even though that's to the extent that that's a separate entity from the other Procarsa entities, they would be a seller. But a seller can be liable if if the manufacturer is insolvent or is not subject to the court's jurisdiction. And then we would seek, of course, the declaratory judgment that Steel Pros is an innocent seller. We've done nothing to cause the damages, and we're not being sued by the plaintiff. The jurisdiction issue is still pending, and this is really the main reason that we have waited to file this claim. It's taken quite a while. And I go over that in my motion, but jurisdiction does determine some important prerequisites to the claim. For instance, whoever is a liable party may depend on which parties are subject to the court's jurisdiction. As I just pointed out under Section 8203, number 7, that's insolvency of a manufacturer or a manufacturer that's not subject to the jurisdiction of the court. Potentially that could make Tube and Pipe liable. Which parties can be sued for indemnity? Obviously, if we don't have jurisdiction over all of them, that would determine which ones against which a suit could lie. And even something I think is even more important is that the party would need to successfully be able, at least have the ability to defend against a statutory indemnity claim. And Procarsa SADCV, effectively, they can't invoke the court's jurisdiction because they've challenged jurisdiction, and that's still out on appeal and probably won't be decided until after the date currently set for trial. They couldn't even join Tube and Pipe and Industrial in responding to my motion. And they won't be able to answer before the Court of Appeals has ruled, assuming that the court they uphold jurisdiction. So this is really the main reason that we have waited to file. We're filing now because the court date is set for April 23rd. Procarsa entities are going to claim that we waited too long, and I think perhaps maybe it's not long enough because jurisdiction is a fundamental issue that would need to be decided. The outcome of the jurisdictional issue will affect the procedural posture and the nature of the case far more than any claim that we're seeking to bring. And then as to the issue of whether our claims would surprise or prejudice any of the defendants, there's only a few issues, only a few fact issues that would need to be decided. There would need to be evidence for or against or arguments made. The first one is, did Blue Racer plead a products liability claim? And I don't think it's disputed that they didn't. I think it's in their pleadings. They pleaded product liability, and under the case law, it doesn't matter if they can prove it. It doesn't matter if the economic loss rule applies or not. They have pleaded it. They have pleaded that there is damage to their property caused by the failure. So it's a products liability claim. The other fact issue are the indemnitors manufacturers. Two of them, the Mexican entities, we believe they are. And then again, Tube and Pipe could be liable under Section 82003. So Blue Racer is alleged products liability, negligence, and breach of a manufacturer's warranty against all of the defendants. So they're all on notice that they're being it's alleged that they manufactured this pipe. And the issue of whether or not a party is a manufacturer is relevant to all of Blue Racer's claims. It has been since the very beginning. And it will continue to be relevant regardless of how the court rules on our motion. They're still going to have to show if they're not a manufacturer subject to liability, they would need to prove that. Nothing has changed there. Then the third fact issue that might apply is the question of, is Steel Professionals precluded from seeking indemnity because it's independently liable? And Tube and Pipe has already alleged in their third-party petition that Steel Professionals acts were a sole producer or producing or sole producing cause of damages. And I mean, they would, even though they're not a manufacturer, perhaps they would have already sought to discover evidence to prove this allegation because they're the ones that pleaded it. And as to the manufacturers, SADCV and Industrial, if Steel Professionals did something that was an intervening cause of the damages, that would be relevant to any manufacturer. And they have good lawyers. They would be looking for to discover any evidence showing that Steel Professionals, a downstream seller, did something that was an intervening cause. That there's no surprise there. And the defendants have had every incentive to discover this and the opportunity to do so. So the indemnity claim, bringing that claim, would not suddenly force them to consider this issue. So for these reasons, we believe that the court should grant our motion. There's no new substantive matter, really. These are all matters that are already in contention. It does not reshape the nature of the lawsuit. It should be reasonably anticipated. In fact, Tube and Pipe has already filed a similar claim against us. So it won't detrimentally affect any defendant's ability to present the case.
So you're saying it shouldn't affect the trial setting coming up?
It shouldn't. The issue of jurisdiction might, but the fact that we would bring an indemnity claim and seek declaratory judgment that we're an innocent seller. I mean, the work should already be done. It shouldn't affect that. We're ready to go if we need to.
Response?
Yes, Your Honor. Mr. Stedman, can you cease sharing your screen if possible?
Yes. Let me do that.
Already did.
Oh, thank you.
Please, the court. Jason Irvin on behalf of Tube and Pipe and Industrial, and I respectfully disagree with Mr. Stedman on a few points. I've not heard any good cause shown for why Steel Professionals answered Tube and Pipe's cross action on August 22nd, 2022, without an issue, just a general denial, and conducted no discovery since that time. The facts of this case, as Mr. Stedman have said, as far as the organization of the parties, has been the same. What I think is a fundamental issue here is that Mr. Stedman he's trying to fit this into 82.002, a products liability action. Well, if given more time, if this had happened 6 months ago, I would move for summary judgment on this claim, and I would have asked Steel Professionals corporate representative different questions aimed at establishing liability under 82.003. There's a bunch of questions and a bunch of exceptions there. I didn't do that. I focused on the statutory indemnity claim that Tube and Pipe made. And if given more time, if this wasn't just about to happen and trial was about to happen, and the court granted them permission, Steel Professionals, to file this late action.
What questions, I guess, would be different with the indemnity? Like, I'm trying to visualize what would be different.
That's fair. So if you go to 82.003, I would have asked more questions about the alteration, the modification of the process by which Steel Professionals.
Wouldn't that be things you'd have to ask anyway?
No, not necessarily. Not to prove my statutory indemnity claim, which is related to the terms and conditions. That whole deposition was about terms and conditions and about Steel Professionals' failure to pass those terms and conditions along to Blue Racer or accept Blue Racer's terms and conditions. And so that was the focus of our inquiry. But in addition, Mr. Stedman is fashioning this as a products liability action. When you look at Blue Racer sued us Tube and Pipe and Industrial, alleging various products liability type claims. The suit against Mr. Stedman by Tube and Pipe has nothing to do with a products liability claim. He's not being sued for strict products liability. And when you read the definition section of products liability action, that is not the action remotely by Tube and Pipe against Mr. Stedman's client, one. And two, when you see the word claimant in that, if you look to 82.003, for example, one of the exceptions to a non-manufacturing seller's liabilities is if the seller, the person who would get indemnity, altered or modified the product and the claimant's harm resulted from that alteration or modification. In other words, it assumes a scenario where Blue Racer sued us both. The typical place we see this is, for example, if someone bought a Samsung TV from Walmart and they brought it home and exploded and they sued Samsung and Walmart, Walmart would avail themselves of 82.002 as a non-manufacturing seller. That's the scenario here, not when there's a cross action being done. But when when Mr. Stedman waits, nearly 2 years after he's first been sued to allege these things, the time to flesh this out and whether or not this is an appropriate claim under the law, it doesn't appear to be what the law contemplates, but it is limited. The time for me to ask the questions I need to ask under 82.003 to prove he's not an innocent seller under those particular terms, that's gone. And so I'm having to make this up on the fly. And so I think that those are the two issues that I do think that if the court were to grant this, it either forces me to do things in a very rushed manner and without the questions I would want to ask of his witness, two, and it forces this court to, I don't have time to judgment on the inapplicability of his claim. And I apologize for interrupting you.
No, it's okay. That's okay. So I guess my concern is that if I don't allow it, then we're looking at a second lawsuit, right? That if we don't allow it in this lawsuit, we'd have to allow it in another lawsuit. And we're just kind of, I don't really understand why there's been such a delay, but I also don't see exactly what additional discovery really would have been done in this situation if they had been there. Based on what this case is about. So I think it's kind of a hard call because under our local rules, I would have to take the second case if there is a second case. I'd kind of rather just get them all over with. So I'm going to go ahead and grant the motion for leave. You guys are, this is a pretty old case at this point. So if possible, I'd like to get this case tried on our next trial setting. I know that the current appeal may impact that. We'll have to talk about that, but I'm going to go ahead and grant the motion. So did you submit an order for me?
Yes, Your Honor.
When did you submit it?
It was, let me see. I believe that was on March 5th.
There it is. Okay.
Your Honor, it should be in your queue now.
Oh, you did. Great. Thank you so much.
You're welcome.
I was just transferring it there myself, so you beat me to it.
Yes, sir.
All right. Anything else we need to chat about today?
No,
No,
Your
Your
Honor.
Honor. Thank you for your time.
And let me ask a quick question. So what is the current status of the appeal?
It is, the court is set it for submission on April 30th. I'm not, appeals are not my wheelhouse, but that's ideally it would be decided on or about
Has
the time
anyone
of-
looked at, does that automatically stay the trial setting, or has the Court of Appeals stayed the trial setting?
it does not automatically stay it, Your Honor, because we did a bunch of discovery and it took a while to tee this up for the court. And we had the court in the last hearing deny a stay so we could ask the appellate court whether or not they want to stay the entire case. We certainly take the position that it is stayed as to Procarza SA de CV, the
I
inspector.
guess, is it stayed as to the trial setting? Will we be, is the,
Your Honor, this is Whitney Beckworth for Blue Racer. Our understanding is that no, it is not. And I know we discussed at the last hearing, our position is that, the court denied Procarza SA de CV's special appearance back in the fall and specifically indicated that the trial setting and schedule would not be delayed. And so our position is that under the law of the case, Procarza SA de CV is in until further notice.
okay, I mean, I'm just, if the Court of Appeals disagrees, obviously, I'll abide by it, but, okay, guys, we'll get ready for trial, and, I guess we have one more motion before then that we'll deal with, so we'll see you in the next motion, okay?
Thank you, Your Honor.
Thank you, Your Honor. Good afternoon.
Okay, our next hearing is on or both, I think I've seen both sides on this case. Elizabeth Martin versus El Pasano Northwest Highway, Inc., DC 1717249. Are both sides here on that case?
Here for the plaintiff, Your Honor.
Yes, Your Honor. Michael Pema for defendant, El Paisano.
All righty. So I know there was some hearings that were canceled and added. So what exactly is going on right now in this?
I believe it's my motion to exclude and Mr. Rafaela's motion for protective order. I believe those are the two that are remaining, Your Honor.
Yeah, Your Honor, we originally said this. We actually did a de novo appeal from the associate judge's order. I believe a lot of those issues could be mute. I mean, we have amended our answers. That was the first thing that was supposed to be heard. That was set for today.
Okay.
And I mean, just for the record, again, we had a hearing and, plaintiff did amend all their answers, which was not in defendant's motion. And the plaintiff removed all objections and produced 76 pages of medical records. So I don't know if the defendant is still seeking these items or seeking
I think he said the
sanctions.
only thing he's asking for is to hear the motion to exclude, right?
Yes, Your Honor. I can explain
Okay.
why plaintiff has not complied with Judge Craig's order. And as such, may I present my motion, Your Honor, real quick?
Yeah, go ahead.
Judge, I believe you remember this case where we went
Are
to
you ready
trial.
to go on the record now, Judge? You never.
I'm sorry.
Oh, I don't know. Do you guys want to be on the record?
Yes, Your Honor.
Yes, sir.
All right. Let's go on the record then. Sorry about that. Let's go on the record on DC 1717249. Martinez versus El Pasano Northwest Highway, Inc. Counsel, make your appearances.
Michael Pema for El Paisano, Northwest Highway Inc., the movement, Your Honor.
Corey Raphael on behalf of the plaintiff.
May I
Okay,
proceed?
let's proceed.
Thank you, Judge. Judge, I believe you remember this case was, we tried this case in December of 2020. And then it was appealed and the Court of Appeals sent it back for a remanded back for a new trial. After the remand, you actually set us for trial within 2 weeks, I believe December 12th of last year. Mr. Raphael, and I did not oppose him, Mr. Raphael filed a motion for continuance because he claimed that his client has seen new doctors and he wanted to get those doctors and their business records and so forth in. As a result, you reset us and issued a new, you reopened discovery, issued a new order, which basically says discovery's designation of experts have been moved to December 27th and January 27th for the defendant, Discovery was to continue until February 27th, and trial was to be held on April 2nd. As a result of the designation of the new doctors, I served a request for production, basically saying, give me the medical records from the 2016 incident, where Ms. Martinez sustained a severe head injury 9 months before the incident that's the subject of this lawsuit. In response to my discovery, which was proper, and I've got Supreme Court case that says it is proper, in Re Liberty County Mutual Insurance Company, it's a 2023 case that says the pre-existing conditions are, because that's relevant to my damages defense portion. And initially, Mr. Raphael objected by saying they're irrelevant, they're overly broad, even though I specifically said the injury that happened in 2016, where she sustained injuries to her body and head. After some communications through email, which they're all attached to my motion, Mr. Raphael said, okay, I don't have any. Again, I had to talk to him or email and say, look, the fact that you don't have them doesn't mean you don't produce them. You need to go and get them because you're the only one that has access to them. Mr. Raphael did not do it. So after a certificate of confidence was established, I filed a motion to compel. The motion to compel was set on March 15th. Before the hearing, before Judge Craig, Mr. Raphael initially filed a motion objecting to a visiting judge, which was an improper motion. Then he corrected himself and filed an objection to associate judge, which again was under the wrong statute and was rejected by Judge Craig. So we held a hearing before Judge Craig, and Judge Craig actually issued an order saying, these are the stuff you have to comply with. She gave him until March 19th to just give me an authorization so I can get the medical records, or in the alternative, produce the medical records that I've requested on my request for production number 5 by March 22nd. When that did not happen, a few days afterwards, I was forced to file a motion to exclude because he's not giving me the information and the documents that judge has clearly ordered him to produce, stating that, well, if I do it, then that makes my appeal of the AJ moot. Even though I told him, Mr. Raphael, as long as you have not, Judge Hoffman has not made any changes to the order, that is an enforceable order. Then on March 28th, which is 4 days ago, I think it was last Thursday or Friday, he sent me 76 pages of records from Parkland. And all of them are not related to 2016. And if I may share with the court some issues that I have with, so anyway, I'll get to that in a second. So he did send me documents, but the documents from Parkland clearly showed that there were filters that were applied. So some of the things are not showing on the records. And I can show that to the court if you wish. I did not get a chance to ask Dr. Ansari, his expert, certain questions because Dr. Ansari says I did not have those records. And specifically, Dr. Ansari testified that all I can see is a frontal lobe injury, which goes towards certain problems that Ms. Martinez complains of, but I don't see any evidence of is it occipital?
Didn't this come up in the first trial setting? I mean,
No, sir. No, sir. The fact that she had a prior head injury did come up, but now Mr. Raphael's expert has tried to distinguish, because the Court of Appeal says you've got to be able to differentiate between the two injuries and show that what happened in 2017 was the proximate cause of her injuries. So he hired an expert 7 years later to examine Ms. Martinez, and in his opinion said, I can tell you that almost everything she complains of could be related to 2016, and I cannot differentiate. However, the back of the head, the occipital, I can't say that word, I don't see any evidence of it. Now, Lord and behold, Judge, we got the medical records from Parkland, and if I may show the court, this is why I believe plaintiff was reluctant in giving us these documents. May I share my screen, Your Honor?
Yes.
Did it happen? Do you see it, Judge?
Yeah.
Okay. If you look at the medical records that are produced, there's is this the right one? There's clearly a reference to a concussion to the back of the head. Had Dr. Ansari seen these documents, his opinion would have changed because he said, the only thing I cannot explain is the hit to the back of the head. It must have happened in 2017 because I don't have any other documents, any other medical records to tell me that something happened to her head before 2017. And what we have here, Judge, is, let me stop this because I got to locate it. What we have here, Judge, is a clear indication from the medical records that she did sustain injury to the back of her head. Had Dr. Ansari seen this, it could have changed the whole testimony. So he's withholding that information from me, from the court, from the jury, so that Dr. Ansari's testimony will be, there is no evidence of injury to the back of the head. As such, the visual memory portion is related to the 2017. But the documents that we got 4 days ago clearly show that she did sustain the exact injury that would have caused the problems with her visual memory, if I may. So this gains
Mr. Payman, just to kind of short circuit this is something you could have requested years ago. You didn't request it. We gave you a break, giving it to you. Judge Craig gave you a break, giving it to you. As close as you did. So
I understand.
I'm going to deny
the
motion to strike.
May I just add one more?
What is our other motion today? A motion to protect?
Yes, Your Honor. The plaintiff filed that motion, and it is to do with Dr. Ansari, who testified at great cost. We did have him testify. Mr. Payman subpoenaed him, but we negotiated, and I said, we'll cover that cost. Now, Mr. Payman subpoenaed him again for trial, and he has not offered to compensate Dr. Ansari for his time. He is not a designated expert. He is a medical treater. He's also subpoenaed him just to come for the first day of trial and stay throughout instead of trying to organize it or at least schedule it, not even try to do it via Zoom. And so Dr. Ansari, of course, said, hey, I can't just cancel all of our, by treatment.
I'm willing. Let me ask this: has he been deposed? Has this witness been deposed?
Yes, Your Honor. He was deposed in March.
Your Honor, but not with the new information.
That's not why I'm asking that though. So you want him to appear by Zoom then?
Well, if I may recommend, Your Honor, if the court agrees, we could play his we could play his deposition and then have him Zoom in just to discuss these new records that Mr. Payman is talking about in order, or if Mr. Payman is willing to, of course, compensate him for his time, which he hasn't offered, and he's actually told me before he won't do, but he subpoenaed the doctor and he should actually have to pay for the doctor's time to come be a witness. And I feel like we should be able to work with the doctor around his schedule, at least to Zoom him in if he needs to he does need to testify.
What I was going to say is I'll allow him to Zoom in at a time that's, when does he want to Zoom in?
I can ask him, Your Honor. I can ask him, Your Honor, or I could reach out to his office and try to, work it out to those days. But again, to save time, can we, if it pleases the court, could we just play portions of his deposition, then have him talk about these new records, which the moment I received them, I sent them immediately over there. So I do take offense to him saying we've doctored medical records. They're printed. We received them. We sent them. But
this is what I would suggest at this point is that you go ahead and play the video, and then if there's anything, and then right after that we'll Zoom them in, and if there's additional questions that need to be asked about these additional medicals, those can be asked. If there's anything that wasn't covered in the deposition, that can be asked. But if anything is covered in the deposition and you guys are going to tread new ground or tread old ground, just object, asked and answered, and then I would sustain it to move this along. I would suggest maybe try to do this Wednesday. How long is your case going to take, Mr. Raphael? How many witnesses?
3 days maximum, Your Honor. I mean, I just have to protect ourselves depending on how long, but I've tried to shorten down as much testimony as possible. So, but I could get him in Wednesday afternoon, play the portion. That way we don't have to go over all of it, proving up his expertise, everything else again, and then have him Zoom in. But again, I asked the court to at least order Mr. Payman to pay for the doctor's time of
That's
course.
up to the doctor's attorney. If the doctor wants to,
Okay.
you're not the doctor's attorney. So I agree that I think Mr. Payman should pay for the doctor. I mean, the doctor's taking time away, but I don't think I can force him to do that. I don't think that's, I mean,
Okay.
I
May
think
I-
the
what I
doctor's
can do-
gonna be kind of
May I be heard, Your Honor?
annoyed.
May I be heard,
well,
Your Honor?
if I may finish, Your Honor, what I would say is, tomorrow morning, just depending how long it'll take to get through our motions and liminees, of course, and our exhibits, but hopefully I can get to Dr. Ansari by Wednesday afternoon. I do know he does clinic in the mornings. He's more flexible in the afternoons, and that way I could schedule him sometime between 12 and 5 on Wednesday.
All right, Mr. Payman, what do you want to say?
Two things, Judge. I did not subpoena Dr. Ansari for tomorrow. I subpoenaed for the third day, for the third, because I knew the first day is going to be taken up with all the motions and picking a jury and all that stuff. When Mr. Raphael, I mean, he jumps around, so it gets a little bit confusing. The point that I was trying to make was that I need the court to know about is, Your Honor, these documents that he sent me on the 28th were received or printed on 10 days earlier. He held on to these documents until Thursday of last week or Friday last week. I don't
Your Honor,
remember.
they came in the mail. It was printed by them and they sent them in the mail.
Judge, I just feel like I'm being,
Mr. Payman, this is a problem of your own making. You could have requested these records years ago. This came up in the first trial setting.
that's true, Judge.
So Mr. Payman, stop interrupting me, please.
Sorry.
This is a problem of your own making. You could have requested these years ago. You didn't request them. You got to work with what you got.
May I,
So anyway, guys, so let's just talk about the schedule.
Your Honor,
So find out when, I'm sorry.
may I respond briefly to what you just said?
Sure, go ahead.
Your Honor, Mr. Raphael designated experts 3 months ago. Had he not designated those experts, I would not need these documents. The
Okay.
question should also be asked, Mr.
I've
Raphael, why did he
heard
wait?
that argument. You could have gotten these records. A pre-existing condition is a defense that was obvious in the last trial setting that the records were never requested. And so you could have designated your own expert. You could have requested these records. The time has passed. So we're going to trial.
I don't have a problem going to trial, Judge. I'm ready to go to
And
trial.
we're not excluding this witness. You can cross them, bring up the new records, and that's what we're doing. So,
That's what I would need. I
all
appreciate
right. So let's talk real quick about tomorrow's schedule. You guys are obviously number one. You're by far the oldest case I have on my docket. So just all the same rulings I've made before are going to stand in terms of the admission of the exhibits. So I don't want to hear argument on the same things we have. So when you provide the exhibit list, just indicate what I've ruled on before. Same with motion. Did you have a motion limited the first time? I don't recall because it was
No, Your Honor, because we both filed, but because of the bench trial, we didn't do that. And also we didn't fight over exhibits. I would say there's only one exhibit which I did file on the last one, and we could bring up in the morning, but it is the police report. Since we subpoenaed both officers, one is dead. He died in the line of duty. So we couldn't get him to, of course, speak on the report. The other one was fired for being intoxicated while on duty. And he's MIA, and the city of Dallas has got back to us that both can be filed. So the police report, we do believe, is prejudicial, and that's the only exhibit we're really adamant on fighting on, just because it's hearsay within hearsay. And
we'll
and
deal
again,
with that. We'll deal with that tomorrow.
Sorry, Your Honor. Thank you.
Your Honor, if I may, there are a couple of rulings that you had before, which the Court of Appeals basically said they should not have happened. So I would like to be able to raise those.
Sure.
for the
About the medical expenses.
Yes, Your Honor. Yes, Your Honor.
Yeah, you can raise those.
So as long as I'm not waiving those, that's fine. You want us there at 9 o'clock, Your Honor?
9 o'clock, you're going to have 30 minutes for voir dire, and we're going to move this thing as quick as we can, all right?
Yes, Your Honor.
In 10 minutes for opening, 30 minutes for voir dire. We're going to move through this as quickly as we can.
But
So
we're gonna do, we got a couple of-
be prepared to have witnesses available to testify tomorrow, because I think we'll get to some witnesses at least. So, Mr. Raphael, you need to let Mr. Payman know which witnesses. You don't have to let him know at this moment, but by 5 o'clock today, You need to know let them know which witnesses you're going to call.
Well, we've already exchanged our witness list, Your Honor.
No, but which witnesses you're
Oh,
calling.
for tomorrow. Okay. All right.
And how
Okay.
we're gonna handle, Doctor, I'm sorry, Judge, is Mr. Raphael gonna notify him that,
Yeah, we're going to
I'll
talk
contact
about
his
it in the
office.
morning.
And if I can't ask, I know it's something for tomorrow. I know you said 30 minutes, Your Honor. I would request 45 minutes for voir dire just because it's not a car wreck case. There's some complications in this case, or at
We'll
least,
see.
and then
We'll see how
15 minutes for
it
opening.
goes in the morning.
Okay. Thank you, Your Honor.
All right, we'll see you guys in the morning.
thank you, Judge.
Okay, I think we have another hearing. Are both sides here on Advancial Federal Credit Union versus Williams?
Nicole Core here on behalf of Advancial, Your Honor. I'm not sure, you had appointed an attorney ad litem for the defendant. I haven't heard from him or made contact since November. They did not file a response to our motion for summary judgment. I'm not sure if they're actually going to appear.
Is that David Griggs?
It is.
Did you notify him about this hearing?
We did.
He's usually very good about that. Let me double check. Did he file a report?
He did not. The last thing and the only thing he filed in this case is the actual general denial back in September.
Okay, give me a second.
Okay.
All right, Mr. Yarborough, what are you here for?
Good afternoon, Judge. I'm here for the receivership motion.
What time was that set for?
It is for 3:30.
Okay.